Thank you for the opportunity to open this debate on an important issue regarding land. Chair, issues of land restitution, land reform, and land tenure reform are not divorced from each other, but remain interlinked and must be discussed together in order to complete the somewhat contentious puzzle on the issue of land in South Africa. Debates on the past and contemporary history on issues relating to land in South Africa emphasize our diversity. While some politicians abuse this to sow division and hatred, if discussed and managed in a mature and realistic manner, progressive land policies have the potential to become a source of development, food security, and unity. In his book, Feeding Frenzy, The New Politics of Food, Paul McMahon correctly states that, and I quote, "Especially in Africa, land has cultural, sentimental, and political meaning. It is a reminder of past dispossession, a symbol of present dignity, and a source of future security. We must view land within its historical context, and in these discussions, we cannot ignore the colossal upheaval, carnage, and massacres during the Mfokani in the late 18th and early 19th centuries. Similarly, our discussions about land must also reflect on what Saul Plaatje referred to when he indicated in his political tract, Native Life in South Africa, that, and I quote, "Awakening on Friday morning, June 20, 1913, the South African native found himself not actually a slave, but a pariah in the land of his birth." This quote was referring to the notorious 1913 Natives Land Act. This act was preceded by a history of race-based dispossession that includes the 1897 Zululand Annexation Act in the Natal Colony, the Glen Grey Act in the Cape Colony, an 1853 Volksraad resolution in the Transvaal Republic, and a ban of freehold for Black people in the Free State Republic. And of course, this was followed by the 1927 Native Administrations Act, the 1939 Bantu Trust and Land Act, the 1937 Marketing Act, the 1946 Colored Persons Settlement Act, the 1959 Promotion of Bantu Self-Governing Act, and the 1971 Homelands Constitution Act, to name but a few. These most prominent pieces of legislation only formed a part of the 60 racially discriminating laws passed between 1913 and 1948, and a further 161 between 1948 and 1991 that resulted in the uprooting of about 3.5 million South Africans of various races. Chair, this was a short summary of the historical legacy that we inherited in 1994 and have to grapple with since then. I hope that the legacy of our children and grandchildren inherit from us will be a different one, hopefully one that is based on both redress for past injustices, but that also constructively address the current national and international demographic, economic, and food-related realities. The Restitution Act was implemented to deal with the constitutional imperative of land restitution, which allows individuals who lost their property as a result of post-1913 discriminatory legislation to submit claims for redress. Redress through land restitution has been delayed by administrative backlogs in dealing with restitution claims by the state. Furthermore, the fact that about 92% of claimants opted for cash in the place of land should be an important guideline for policies relating to redistribution. The cash claims enable individuals, many of whom currently reside in urban areas, to purchase property and build homes and livelihoods in our towns and cities. This is also an indication of a realization among restitution claimants that land in South Africa is not an instant source of wealth. Without ignoring the words of Paul Macman that I quoted earlier, we must approach the issue of land in a manner that takes into account our current realities of rapid urbanization, the need for food security and economic challenges, with the only certainty being the uncertainty of an unpredictable future. Land reform, what is also referred to as redistribution, and security of tenure are not restricted to rural areas, but should be an important part of our urban planning. In this respect, we support policy proposals that will optimally enhance land usage and productivity in rural and urban areas. Such policy options must create an environment that is socially just and fair, and in which existing rights are carefully aligned with our national objectives of redress through pragmatic, constructive, and productive redistribution. Chair, I've outlined the historical need for redress and would now like to deal with some important environmental and economic issues relating to land in South Africa. A 2015 World Wildlife Fund South Africa report indicates that while 69% of land in South Africa is estimated to be good for grazing alone, only 13% of land is arable, good for cultivation, and 3%, only 3% is considered to be high potential agricultural soil. This implies that South Africa is not conducive for the type of agriculture envisioned in multi-beneficiary cooperative land reform projects that government has tended to implement and that are set up for failure. How does our agricultural sector survive in a country that is not agriculture friendly? This is explained by Jeffrey Hartz and Greg Mills in their book, How South Africa Works and Must Do Better, in which they state and I quote, "Like any other sectors, those who survive and prosper will be the better farmer, marketer, and entrepreneur, improving yields and technology and inserting themselves into local and global value chains. Farming requires a combination of skills and expertise, capital, modern infrastructure and equipment, and of course land, which may be owned or rented by agricultural entrepreneurs. The success of commercial farming in South Africa is based on economies of scale, which has resulted in about 20% of commercial farms supplying 80% of all food in our country. This is supplemented by small-scale and subsistence farming. Despite some incremental improvements over the past 27 years, equitable access to land remains out of reach for most South Africans. Untransformed historical spatial arrangements ensure the entrenchment of inequality. Approximately 17 million South Africans still live in former homelands, which are in some instances on the most fertile land in the country. Last week, the DA Shadow Minister of Agriculture, Land Reform and Rural Development, Honorable Thandeka Mbabana, emphasized comments by the ministry that citizens living on 10.5 million hectares of land in rural areas still live in property owned by apartheid-era state institutions. This statistic supplied by the ministry is an admission that the ANC-run government flagrantly violates the fundamental rights of rural communities to own their property as stipulated in Section 25 of the Constitution. While the Constitution does not instruct the state to give everyone land, the Constitution instructs the state to foster conditions which enable citizens to gain access to land on an equitable basis. Control over much of the land in communal areas rests in the state. Individuals and families occupying this land are subjected to various forms of land rights that are in most cases informal, uncertain, and vulnerable. So we can ask, what can be done to remedy this situation and ensure that our rural populations have access to security of tenure? In other words, own their own property. Chair, allow me to propose, among others, a few of the most important DA proposals in this regard. First, we must create a proper land registry by surveying all currently unsurveyed land in communal areas. Understanding where the boundaries between properties are is the first step in improving tenure security. Secondly, we must provide security of tenure through private title to all landholders who want it. This approach addresses the distinction between individual and communal title, as it would be up to the landowners to decide for themselves where they want to own the land, whether it's individually or whether they want to form a communal property association. However, if a landowner opts for individual rather than communal title, they must get it. Third, include communal use rights such as for grazing or accessing water points as a condition in the title deed, as it is already standard practice in servitudes in many cases. Fourth, couple the process of surveying and titling individual plots of land with an infrastructure needs assessment and development that focuses on access to roads, water, financing, training, and mentoring. This will ensure that those private landowners who want to enter agriculture are able to do so successfully. Fifth, undertake to protect the rights of beneficiaries to participate in the cultural life of the traditional community of their choosing. In other words, with the exception of assigning control over land ownership to private owners instead of traditional authorities, all other rights of traditional authorities would remain undisturbed and protected. Six, a comprehensive land audit needs to take place with a proper land registry. Provision must also be made for protection against predatory buyers through the provision of minimum land values by the Office of the Valuer General. These aspects will form a part of a DA's private members' bill that will be tabled in the National Assembly. There's no provision anywhere in the Constitution that provides for any individual to be barred from owning property. In fact, Section 25, the Property Clause, makes it clear that no one may be deprived of property, and that a person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws is entitled to tenure which is legally secure or to comparable redress. A recent High Court judgment indicates that people living on customary land under control of the Ingonyama Trust are the true and beneficial owners of that land. The court also found that the Minister of Agriculture, Land Reform and Rural Development has neglected her legal duty to respect, protect, and promote these informal land rights. The courts will similarly reject legislation that infringes on the constitutional rights of individuals to own property and have such property arbitrarily taken away from them by the state. The ANC's treatment of people in rural areas as second-class citizens by banning individuals from owning their land violates these provisions of the Constitution, as well as the right to equality. The ministry confirmed that land remained registered in the name of the apartheid state. Listen to this, the reason: because no legislation currently existed to transfer land held in trust by the government to rural communities, 27 years after 1994. As Honorable Mbabama correctly indicates, this too is nothing less than an admission of outright failure by the ANC government to enact legislation to provide tenure security and ownership rights to rural communities. Contrary to its own Freedom Charter, the ANC-run government has been fixated on preventing people in rural areas from owning land and on expropriating current landowners, rather than focusing on land reform models that are based on redistribution and economic empowerment. Chair, Venezuela and Zimbabwe are examples of where the legislated nationalization of land and other property has devastating impacts on the economy and food security of those countries. In Venezuela, the economy collapsed due to policies of nationalization, which included expropriation without compensation, leading to massive famine. It was reported that by 2017, more than 3/4 of Venezuelans had lost an average of 12.5 kilograms in body weight due to national food insecurity, and 61% of the population are going to bed hungry. Similar policies regarding expropriation of land in Zimbabwe led to the collapse of the economy and currency, an unprecedented 90% unemployment and famine. The many economic refugees in South Africa from Zimbabwe attest to this. All economic and political commentators, as well as international precedent, indicates that giving a government powers to arbitrarily expropriate property without compensation creates economic uncertainty and new threats. Such threats include an unwillingness by international investors to invest in a country where their property rights are not secure, a further capital flight and disinvestment, and an unwillingness to invest in agriculture, especially by banks. Agricultural economist Wandile Shihlobo indicates that agricultural debt was 187 billion in 2019. What will happen to this debt if we have expropriation without compensation? We must also acknowledge the High Panel's report, the conclusions that indicated that the reason for the failure of land reform is a result of corruption, the channeling of resources to the elites, and a lack of support. And Chair, we in the Free State have experienced that in the Gupta-linked Vrede Dairy project, where for 9 years the beneficiaries were excluded from the project. There was massive corruption and channeling of resources to the elite. The DA fought for the rights of these beneficiaries in Parliament, the legislature. We went to the Public Protector, the Zondo Commission, and to the courts. Chair, land redistribution in South Africa must be individual and family-based, with tenants and farm workers given priority and support in order to give them access to the necessary markets and enable them to become active in the commercial farming sector. Property rights must be legally secure as envisioned by the Constitution. Land redistribution must not be restricted to rural areas. Policies and legislation must make provision for inclusive urban development that includes residential, commercial, cultural, and recreational land to cater for the rapid urbanization that is a characteristic of our modern societies. When it comes to justice for our most marginalized and rural urban communities, the DA will fight to free our people who are still enslaved in an apartheid-style property arrangements that the ANC continues to protect. Thank you, Chairperson.